Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. Today is June 6th and it's actually day 32 of the Mass Casualty Commission proceedings, and I'm going to do a video about that later. That we have Truro Police Chief Dave McNeil on the stand today. He's being cross-examined this afternoon, but what I want to talk about is an interesting book I read yesterday, and it was the book by Mass Casualty Commission Commissioner Kim Stanton, who was a lawyer in Toronto before being named by Bill Blair, the federal public safety minister, to become a commissioner in the Mass Casualty Commission proceedings. So Commissioner Stanton had, as she was finishing the book, and she describes this in the epilogue, that it was in the course of her completing the edits on the book that she was named as a commissioner to the Mass Casualty Commission. And she wrote this book, and it's called Reconciling Truths. And there's some themes and I think lessons that the Mass Casualty Commission can draw from this work. And it might also help us, to help it fulfill its mandate and increase the sort of level of public trust in the commission itself. But I think it also gives us some insight into perhaps some of Commissioner Stanton's influence over the structure of the commission so far and the sort of the unfolding of its proceedings. Now, the book itself is close to 400 pages long, although there's really only about 200 pages of content. So I was able to read it over the course of a day. A little bit of rain yesterday in Nova Scotia, so took advantage of that opportunity. I did not get the hardcover $90 version of the book from University of British Columbia Press. I got the $17 version on my Kindle. So if anybody's looking to read it, you don't need to pay law school textbook prices for the book. So now much of the book focuses on Canadian inquiries or truth commissions, which, as she describes, are sort of a subset of public inquiries. Public inquiries can be, it's a very malleable legal term. Any kind of a public inquiry can have different features and focus. But the truth commissions, which are sort of an international movement, and they've developed over the last few decades internationally. So she's trying to situate the Canadian sort of Aboriginal government relationship in the context of those international truth commissions. And talking about the ongoing and historical tensions between in the relationship between the Canadian government and Aboriginal peoples. So in the introduction to her book, Commissioner Stanton suggests she states that the genesis of the book, how she got it started, was after a discussion she had with a participant in the murdered and missing Indigenous women and girls inquiry, where there was all kinds of doubt about how the inquiry was going to work out, if it was going to provide any tangible help. So that was sort of in the introduction what got her thinking about this. Commissioner Stanton has a history of international legal work, has traveled internationally and worked on some of these commissions, or at least studied them. So it's an area in which she's familiar. She in the epilogue, so after the book is completed, there's a short epilogue where she describes being named as a commissioner of the Mass Casualty Commission. And actually, to her credit, I'd say she recognizes that as now an inquiry commissioner herself, that she now has a vested interest in her own theories on inquiries. So I think it was a really interesting read. It was a fairly easy read. I wouldn't describe it as having the sort of academic density or rigor that you might expect from a main textbook of a law course. And I don't really think it's aiming to be that, other than the price tag perhaps. It seems to me more aimed at an educated general audience. With an audience that would have an interest in Canadian Indigenous reconciliation, and putting that all in the context of this sort of International Truth and Reconciliation Commission movement. Most prominent one people might be familiar with would be the South African, post-apartheid Truth and Reconciliation Commission. That's the sort of, one of the gold standards, at least, that other countries have followed internationally. if you're thinking about this book as an audience, perhaps, part of the material, not the complete material, but part of the material perhaps for a law course that was focused on international human rights law. So it talks about several Canadian case studies, and I'll mention them in a minute, and sort of connects them to truth commissions in places like South Africa, El Salvador, Australia, Argentina, Bolivia, Germany, Nepal, Uganda, United States, Zimbabwe, other places. The main Canadian case studies were different inquiries. So the first one was the Mckenzie Valley Pipeline Inquiry, which reported in 1977. Others were the Manitoba Aboriginal Justice Inquiry, which reported in 1991, the BC Missing Women's Inquiry in 2012, the Royal Commission on Aboriginal Peoples from 1995, the Truth and Reconciliation Commission from 2015, and the Murdered and Missing Indigenous Women and Girls Inquiry from 2019. So the main thesis of the book is that, despite their problems, and there's many problems that she identifies throughout them, inquiries or truth commissions can be a valuable public policy tool, but this potential utility depends not so much on the terms of reference or the political creation of it, but on the effectiveness of its leadership and the processes used by the commission. So throughout the book, she repeats this theme where the success of an inquiry really depends on the commissioner having the ability to lead and, institute effective, appropriate processes for the subject matter. She says, and I'll quote, the commissioner's interpretation of the mandate is one of the critical factors in whether an inquiry fulfills its social function. She talks about social function as well. Social function being, you bring people in, you educate, as you're doing your inquiry, you're doing it in public, so you're educating the public as well. You're sort of generating and fostering public opinion for change, and you're doing all this as it's ongoing, and so people accept not only the procedure chosen, but the sort of broad direction of an inquiry before a report is ever issued. So people can basically see the report coming, and there's been acceptance of the general themes of wherever the inquiry is trying to conclude. So she also, in going through it, seeks to define some of the best practices in truth commissions. And so now maybe it's important to define truth commissions as opposed to public inquiries more broadly, because really I think that's one of the ways that the Mass Casualty Commission has fallen short, or that's the source of some of the criticism, or the reason I think is that there's a misunderstanding among the commissioners, it seems, about what kind of an inquiry this is supposed to be, and it ties back into this book because she's analyzing truth commissions, and truth commissions are meant to deal with human rights violations, particularly patterns of human rights violations, and they're usually used by countries, like South Africa, Uganda, El Salvador, these places that were coming out of authoritarian or sort of systematically, racist, in South Africa's case, regimes or societies, and emerging into something more democratic. And so this sort of legal mechanism of the Truth Commission, which is not a trial. It doesn't have the time issues, the lengthy time frames, and all these things that are associated with trials. That it's a different kind of a legal mechanism that can find, search for accountability among the violators of the previous generation or the previous regime, without sacrificing the sort of nascent emerging democratic structure that is, organizing and trying to, call this inquiry or commission. And, she says they're more adept at advancing, that is, truth commissions are more adept than trials at advancing other goals, like restorative justice goals, like acknowledging the suffering of victims. So they're more victim-centered, and they typically deal with human rights issues. So, as you're sensing, not exactly analogous to the Mass Casualty Commission. So the first and the most prominent inquiry in Canada that is used as an example, and a good example, is the Mckenzie Valley Pipeline Inquiry, which had one commissioner, and it was newly appointed at the time Justice Thomas Berger, who received very high praise from Commissioner Stanton here. The Mckenzie Valley Pipeline issue was up in the north, and there was a question of whether there was reserves, oil and gas reserves found in the Arctic. Could they be pipelined south and connect ultimately to the United States? Well, there were big issues because there were Aboriginal land title claims that had to be addressed, and it just wasn't going anywhere. And so the government appointed Justice Berger as a commissioner to look at that. So one of the things he did was took a very expansive view of his terms of reference. He looked at it and said, well, I need to look at Aboriginal land title claims in order to do this properly. If we're going to talk about a pipeline, it's going through Aboriginal land. I need to look at all of that stuff. He took an expansive view. But the other things he did were maybe just as important in Commissioner Stanton's view, one of which was he brought everybody up to the north. All the media, all the parties, everybody had to go up to the north and experience life there, and they were grounded in that experience by seeing the cultures, and it wasn't just the sort of vast, empty, mysterious north, but real people in real communities. Media was brought along as well, so that they were reporting back, and then sort of telling the story to the Canadian population in a way that hadn't been told before, hadn't been told under these circumstances, certainly. So the other thing he did was and that was part of it, Commissioner Berger had what Commissioner Stanton describes as a media engagement strategy. So trying to make sure that it was being covered by prominent journalists, and being covered in a way that explained what was going on in a understandable way for the Canadian population that really may not have had a great understanding of Aboriginal land title claims. So that was an important feature of it, and she compares it to the other, like the Royal Commission on Aboriginal Peoples, which did not have an effective media strategy, and then so those recommendations just sort of, they didn't get implemented. There was low public acceptance of the recommendations, and it really, they didn't take hold. It didn't have the same kind of impact as the Mckenzie Valley Pipeline Inquiry. And she was also particularly critical of the Murdered and Missing Indigenous Women and Girls Inquiry Commissioner for not rectifying failures along the way with respect to communications, transparency, and accountability, that were sort of plaguing that inquiry as it went along. So I look at that and I wonder about, the self-awareness during the Mass Casualty Commission and some of the problems that are being dealt with. How are those being addressed? They're certainly not being addressed, publicly. There's some subtle changes in procedure that I'm noticing in the Mass Casualty Commission, a little less on the foundational documents, a little more on the testifying and the witnesses, but they haven't really come out and discussed that openly, as Commissioner Stanton would seem to be advising be done in this book. So that was interesting. So another theme that emerged was that the Truth and Reconciliation Commission was more for proceedings to be more victim-centered, with more community hearings, fewer lawyer-dominated proceedings. Now, again, recall that she's talking about truth commissions as compared to fact-finding inquiries. And for this, she does emphasize several times that she sees the benefits to having fewer lawyers involved, and fewer of these other features of trial, such as cross-examination and oaths and such. So this ties back to what I'm seeing and what everybody's seeing in the Mass Casualty Commission, which is not having that rigorous cross-examination that you would expect to see in a trial, and that seems to have been a problem so far. So she lists off towards the end of the book what she describes as factors for success in truth commissions. And it's certainly, as you go through this list, you'll have in mind, no doubt, some of the shortcomings of the Mass Casualty Commission. Commissioner Stanton advises that to succeed, a commission must be led by someone with vision, courage, and compassion who can command the attention of the public. So that's on the commissioner side. In terms of process, she says that it must engage the broader community, create knowledge and understanding well before the final report is issued, have a clear media strategy, engage the public, hold public meetings that are not lawyer-driven, use the first language of the witnesses, more relevant for the some of these Aboriginal inquiries, I would suspect, welcome independent research, and make clear that all evidence adheres will be valued. All very important. Actually, one of the other recommendations, wasn't in the main list that she mentioned, was starting your hearings with those most affected, so that it grounds, the victims, so that it grounds the commissioners in that work and sort of has it sink in right away why everybody is there. Just on that point, I would note that we are now in day 32 of the Mass Casualty Commission proceedings, and we have heard from a total of one resident of Portapique so far, and really that was just the lady that identified where the Blueberry Field gate was and that it was knocked over. So we haven't really heard from victims yet through the proceedings themselves. We've heard lots through the media and outside of that, but Commission not taking Commissioner Stanton's advice in that regard. So, that's one thing. The effective media engagement strategy. I know there is a media engagement strategy. I think most people would agree that it hasn't been particularly effective. They didn't bring the proceedings to the place where things happen. Instead of coming to Truro right away. I mean, they're in Truro this week, but they're going back to Dartmouth next week. And they've had most of the hearings so far at the Nova Centre in Halifax, rather than having it in Truro, close by Portapique, and where most of the events took place. So we have the Nova Centre instead. And I'd say, to the extent that it's been a unifying force and it has fulfilled the sort of social social work of it, that it's been at its own expense. People are learning about the RCMP. They're learning about the shortcomings, the response, to know that they were underprepared, to know that they lacked trust. The RCMP lacked trust in the people, and that the RCMP have been trying ever since these killings to cover up their mistakes and their failings. So we have enough information to know that, but we only really know that, or the public really at large only really knows that, because the Mass Casualty Commission itself has been facing such criticism that's drawn attention to the lack of scrutiny, or the behavior of the RCMP, lack of disclosure, all those sorts of things that are coming up with respect to the police. So I'm not sure that seems unlikely to have been the goal of the Mass Casualty Commission, to sort of take the hit themselves in the course of providing information to the people that they can make their own decisions and unify around a message. I don't think that was the intention. I can't imagine it would be. So upon, I guess, reading Commissioner Stanton's book on inquiries, it would seem that the main issue might be a fundamental misunderstanding of what kind of an inquiry this is supposed to be. Non-lawyer driven proceedings, where we just listen respectfully and uncritically to everyone's truth. While it may work well in a setting where the facts are more or less established, there's been a pattern of human rights violations, and we really just need to process all of that and hear from victims. It doesn't work so well when it's a factual inquiry, where we're trying to establish facts in the face of powerful, obstructive institutions that have their survival on the line. So it's a much, much different situation. And so, the procedures and the sort of soft procedures, non-court-like procedures being chosen by the Mass Casualty Commission, trauma-informed procedures, to use their term, don't quite work so well. So it's possible that Commissioner Stanton views the Mass Casualty Commission as being victim-centered, when really its most prominent characteristic should be analyzing the response and capacities of our emergency response stakeholders. So hopefully, unlike the commissioners whom Commissioner Stanton has critiqued, that she'll use her knowledge base and her influence within the Mass Casualty Commission group to bring it back to a place where it can be trusted to deliver on its social function, to educate the public, and such that political will is generated to ensure that the injustices of all of this are not repeated. So anyway, that was sort of my book report. Not quite a book report per se, but it was. I enjoyed the book for what it was, but it I think shows what some insight into what might be some of the issues with the Mass Casualty Commission proceedings. It's just a different kind of an inquiry than Commissioner Stanton is used to thinking about, and it's perhaps that she's trying to, take something that she's learned about these other inquiries and try to make it fit into this scenario where it's not a very good fit. So we'll see if there's some adjustments along the way, but I thought I would take a look at that book. I thought it was going to be a more academic, difficult to read account. I wasn't. I was able to get through it just in a day's reading and enjoyed it for what it was, and I hope that you found my analysis of it useful in the context of the Mass Casualty Commission hearings, and so I'll post that up for everybody to see. All right, so thanks for watching. Thanks for listening. I'll be posting my thoughts on day 32 of the proceedings once they're completed later on this afternoon. All right, I'll see you next time.